you use marijuana all day, every day.
Not really all day, every day, but I use it daily, if that helps you with your interpretations. Mr. Low-Key Honorable Judge Tonight. And whose expense? Mine? Because if it's mine, I'm not doing it. Sanction, give me $100 fee. Woo,
Okay,
woo.
well, so I am finding you in direct contempt.
Okay, one fine.
Finding you $100.
Okay, make it 2. Damn. I said 2 words. Dumbass. 3 contempts. Blah, 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 blah.
Most people assume a court-ordered psychological evaluation in a custody case is optional. In Texas family law, it is not, and refusing one on the record is itself evidence the court can use. Ms. Stiles came to her custody hearing in Dallas County without an attorney, admitted to daily marijuana use before she was even asked, told Judge Drew Tenike of the 301st Judicial District Court that nobody could force her to do anything, and left before the hearing was over. She was not in possession of any of her children. She had not paid child support in over a year, and Judge Tenike still had 5 motions to rule on.
Good morning. How are you all?
Morning, how are you?
Morning.
Okay, what can I do to help you all today?
Yes, sir.
Get us off of your docket is what you could do. But go ahead, Lacey. Start talking.
That's pretty specific. Ms. Kimball?
Yes, sir.
Specific.
Go ahead, Ms. Kimball.
A custody evaluation was completed, and so we have filed a motion for drug screening and a motion for a psychological exam based upon that custody evaluation recommendations.
Blah, 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 blah,
And
blah.
stop talking. You'll be able to respond in just a second. Ms. Kimball, you can go ahead and finish, and then Ms. Stiles, you'll have an opportunity to respond in just a minute.
I need to pause the hearing. I don't have an attorney. Can you give me some time to get an attorney? I haven't had adequate time to obtain an attorney, and my attorney withdrawed, and I'm going to need one appointed by the state.
That's not an option. There's nothing there unless someone's asking that someone be held in contempt and jailed, which is not something that's set in front of me, or it's a action by the state to terminate a parent's rights or something like that. Those are the only times I have the ability to appoint an attorney for you.
Okay, then go ahead.
We also had sent discovery out as laid out in our motion sometime back. I had worked with Ms. Stiles' prior counsel and had agreed to 2 extensions. And then we ultimately never got a response, and she filed a motion for protection.
She got plenty of responses. Objection.
What's your objection? Hold on, wait a second. Ms. Stiles, you just need to object and then let me know what your objection is. Don't yell at her.
Objection to hearsay. How do I submit my documents to you directly?
Hold on. So, Ms. Kimball, are you saying this was something that happened between counsel?
Yes, back in November. We are now setting this hearing is for our motion.
She also represents Cody and all fucking sit there.
Okay. So, Ms. Stiles, I'll unmute you in just a second. You need to let Ms. Kimball finish what she's saying, and then when you're talking, she'll let you say what you're saying, unless one of you has an objection that is a legal objection. You can't just talk at the other side. So, Ms. Kimball, why don't you just go ahead and finish telling me so you said that you're wanting a drug screen, so a drug test, and do you say psychological or psychiatric? I thought you said
a psychological exam. And then we have a order to compel Ms. Stiles to turn over the responses to our discovery request, to provide dates for a deposition, and for attorney's fees for $1,500.
Okay. All right. So, Ms. Stiles, I'm sending you a prompt to unmute. If you just unmute yourself, you can respond. What is your response to those things? Let's go with the drug screening part. Do you have an objection to taking a drug test?
I'm not going to pay for it because I'll tell you up front I'll file for marijuana.
When was the last
But
time?
I'm happy to take it on.
When was the last time you took marijuana?
I use marijuana daily.
Ms. Stiles isn't the first parent to lose ground in a Texas custody hearing over drug use and non-compliance. Here are 3 others who face the same court authority and what happened when they did.
All day, every day. And it's legal in what states? California. So we can either get there or not get there. Your choice tonight.
Okay.
I'm glad to take the drug test.
Stop.
Okay, go. It's going to be on his expense, but
Stop. I'm pretty low key. We're in court.
fed up with Miss Kimball.
You need to be respectful.
I'm
So
fed
you can
Kimball.
just, if you're gonna use
Respect-
my last name, that's
Okay.
fine. Just say Judge Tonight. Okay, it's pretty easy.
Okay.
So you use marijuana all day, every day.
Not really all day, every day, but I use it daily, if that helps you with your interpretations. Mr. Low-Key Honorable Judge Tonight.
I'm not interpreting. I just said what you said.
Okay.
What is your response to the request for a psychological evaluation?
Not doing it, and you cannot force me to do it. You cannot physically make me go and show up and partake in anything that I do not want to partake in. Yes or no? Do you agree or not agree?
You don't get to ask me questions right now. I'm asking
That's
your position.
That's my response to you.
Okay.
You will not get any. I'm not doing a psych eval, and you cannot make it mandatory.
Interesting. In terms of the motion to compel, where they're talking about discovery, what's your response to their motion to compel?
Have you read their discovery? When are you going to view my videos?
Ma'am, you need to answer my question.
I answered your goddamn question.
All right. So I'm going to warn you that it is completely inappropriate to swear like that in court. You need to take yourself, you need to put yourself back on camera. Thank you. I'm not going to allow that. So if you do that again, I'm going to sanction you $100 for every time that you swear in court, because that's not appropriate. You just need to not do it. You can answer the question and be respectful to Ms. Kimball and to the court. And I'm not going to tell you how to answer, but you can just say whether or not you're in agreement with something. In terms of the motion to compel, I haven't heard it yet. So I'm just trying to find out from a cursory standpoint what your position is on these 4 issues so that I can figure out if there are partial agreements.
Under Texas Family Code, Section 105.001, a court can order any party in a custody proceeding to take a drug test at any point. Refusing that test is treated the same as failing it. Under Section 107.105, a psychological evaluation can be ordered when mental health is relevant to custody. The party whose conduct prompted the request bears the cost. These are not requests. They are court orders.
Or not. It sounds like there aren't. So based upon your response, I'm going to take it that you're not in agreement with their motion to compel. In terms of their request for deposition dates, what's your response to that? I sent you a prompt to unmute yourself.
What date?
Ms. Kimball, do you have proposed dates?
I would propose.
And whose expense? Mine? Because if it's mine, I'm not doing it. Sanction, give me $100 fee. Woo,
Okay,
woo.
well, so I am finding you in direct contempt.
Okay, 1 fine.
Finding you $100.
Okay, make it 2. Damn, I said 2 words.
Ma'am, I don't think you want to do this. At least the people in the courtroom seem to think you don't want to do this. I will, not because you're requesting it, but because you're not following the order. As I said, sanction you.
Please do.
Let me do it. So that's
Please.
$200.
Here, I'm sure she wants my apartment number, right? Turn it to Miss Kimball. You're going to want.
Stop. That's not something that she asked for. Ms. Kimball, what dates?
No,
what
been
dates are you
everybody
requesting?
else.
I would propose August 30th or September 2nd.
Okay.
How long?
Are you wanting how long? That's a valid question. Is it half day, an hour, 2 hours? What do you
I
anticipate?
would anticipate a full day.
So what, the
Ms.
30th or the 2nd?
Which of those dates works better for you, Ms. Stiles?
What time? Dumbass. 3 contempts.
You're correct. That is 3.
Yep.
Supposed to start at 9 a.m.
What date?
Stiles, that question is to you. Never
I
mind.
said what
I'm not
time?
gonna let you
Time,
pick.
date, you know, these
I'm not
things.
gonna let you look. You don't get to do this for your own pocketbook. I'm muting you for. All right, I'm going to count that as another violation. So, in terms of the request for the deposition, she didn't have any objection. I'm going to note for my own record. that she opted out after flipping me off. I won't comment. So I'm going to grant the request for August the 30th at 9 a.m. in your office, in order that, I mean, it would normally have your address and time and everything like that, but just so there's no confusion, since she disappeared, I will sign an order that orders that the deposition take place. Okay, I'm going to go ahead and excuse you all at this point. I wish you all the best.
Thank you, Judge.
Ms. Stiles left that courtroom before the hearing was over. The judge kept going. 5 motions were on the docket: drug screening, psychological evaluation, motion to compel discovery, deposition dates, and $1,500 in attorney's fees. She objected to all of them. She provided arguments for none of them. She admitted on the record to using marijuana daily, refused a psychological evaluation she called impossible to force, swore in open court, called the judge a name, flipped him off on camera, and disconnected. None of that stopped the hearing. The judge worked through every item on the docket methodically, reading the interrogatories, reviewing the discovery responses, considering the custody evaluation recommendations, and ruled on each one. She is not currently in possession of any of her children. She has not paid child support in over a year. The drug test and psychological evaluation she refused to agree to are now court ordered. The $1,500 in attorney's fees is now a judgment against her. The deposition is scheduled. The discovery is compelled. What happens when she receives those orders and whether she complies is the next chapter of this case. Subscribe to Court Archives Official and stay in the room. Like if Judge Ten Eyck handled this exactly right. Comment below. Did Ms. Stiles hurt her own custody case, or was she standing her ground? And share this with someone who needs to see it.